Good afternoon, everyone. Thank you for joining us today on our session with respect to disability attendance and long-term leave. So my name is Claudia Desjardins-Bellil. Again, I'm the Montreal office managing partner, but also the head of the National L&E Group. I'm joined today by my partner, Jill Wilkie, who is in Calgary. So thank you for joining us. And again, I apologize today out of all days, I had to lose my voice. So bear with me during the session and thank you for your understanding. So why did we choose, Jill and I, today to discuss with you disability management? Because we've noticed in the past few years, especially since COVID, that this particular topic has come up in our practice quite a lot. And I don't know if it's a consequence of the pandemic or if it's just the way life evolved, but we see more and more demands for duty to accommodate, or demands for accommodation. And we wanted to discuss that with you today and the new trends that we see and new types of demands that we see. So if we could move to the next slide, I'd like to give you the outline of today's session. So we're going to start by exploring with you what the duty to accommodate is. That may be a concept that you're already familiar with, but I think a good refresher is always nice to have. Then we're going to move on to the duty to inquire. And we've put two little stars here because duty to inquire is slightly different in Quebec. Donc, cette obligation de se renseigner est un petit peu différente au Québec. Je m'excuse, je vais aller d'un petit peu du français à l'anglais pendant la présentation. Afterwards, we're going to move on to the emerging issues that we see, new issues, new types of demands that we see. We're going to move on afterwards to accommodation when it's gone too far. So what don't you have to do as employers? Because sometimes as an employer, we believe or we're under the impression that we need to do everything and we need to accept right away our employees' request for accommodation, but that's not necessarily the case. And then we're going to end with final notes, key takeaways for you guys to be able to manage absences in your workplace and disability, which leads to duty to accommodation. We can move on to the next slide. We've prepared for you a little roadmap for the duty to accommodate as a refresher. So it's really divided in 4 steps, duty to accommodate. And I think that roadmap really helps understanding what we need to do as employers when we're faced with such a situation. So the first element that we need to look at is identify whether or not the right to accommodation is established. And we'll talk about it in details later, but that's the starting point because you may be facing situations that don't even require accommodation, and you may think that you do have such an obligation, but it's not always the case. The second step is really to collect relevant information. The third step is to consider accommodation options, and that's crucial in terms of being able to explain to a court if ever a complaint or grievance is filed that you've explored all of the possibilities. And the fourth part of the accommodation process is really to implement your accommodation. And what kind of follow-up do you do? Do you do return to work plans? What is your best practice to adopt in your workplace? So we'll be looking at that divided in those 4 categories. Next slide.
And I would say too, Claudia, just before we move on from the 4 steps, it's really important as you move through that process to document your work all the way along the way so that you can prove all of the steps that you've taken. Really important to document all the inquiries that you've made, the information that you've received, any brainstorming that you've done, and also any options that were considered, and perhaps those options may be discounted at the end of the day, but to really show your work through the process. So when you're identifying that there is the existence of that protected ground, because of course there has to be before you have a duty to accommodate, you're going to be doing that by collecting information, reaching out to those medical providers through the employee for a request for information to ground that there actually is an underlying disability. And then when you're doing that brainstorming around accommodation, there is that cooperation in that process, of course, if you're dealing with the union or, of course, directly with the employee, but making sure that you're documenting that process. And then, as Claudia said, when that accommodation ultimately occurs, perhaps there's a return to work plan that's documented, or even the accommodation that's decided and agreed upon itself should be documented. So that documentation piece is key, so that we can prove that you've taken all the steps.
Yeah, and we'll dive more into that in the next few slides, but that's definitely one of the main elements to consider, Joe. Good point. Now in terms of the accommodation process, so we say to engage in an interactive process. Why do we say that? Because as Jill just outlined, the accommodation process is really a group work. So yes, you do have an obligation as an employer, but you need to communicate and interact with your employees, and if unionized, also the union, to ensure that the accommodation process is successful. So that's why we say it's very interactive. We need to establish as a first step in the accommodation process, as Jill also mentioned, whether or not there is a protected ground, because that's when you're aware of a situation and aware that there is a potential violation of a protected ground, such as a handicap, that your obligation to accommodate will be triggered. So it's really important to determine what that protected ground is. And then when it comes to disability, if ever you're made aware that an employee has a disability, crucial step to take is really to gather medical documentation. And that could be really tricky because employers sometimes shy away from demanding information when it comes to a disability, thinking that it would automatically be a violation of employees' privacy. But it's not anyways all the time. So you absolutely need to be mindful of what the disability is, what you're trying to achieve, and then gather the medical information that is appropriate. There are some distinctions, however, that we need to make. So for example, in Quebec, there has been a modification in the legislation which makes it such that you cannot request medical information unless you meet a certain threshold. So you need to be mindful of those specificities in your own jurisdiction, but it is a crucial element of the process. Now to you, Jill.
Yeah, for sure. When you're dealing with that gathering of information, and we'll get into this in a little more detail, but really you're trying to establish, like Claudia said, whether there is an underlying disability present. We don't need to know the diagnosis. Employers aren't entitled to that diagnostic information, although sometimes your employees will tell you what's happening for them. But you do need to know prognosis. Are we dealing with something that's temporary? Are we dealing with something that's permanent and long-term? We also need to know if the employee, if they're coming back on a return to work, if they have restrictions, if they have limitations. All of this is so that you have enough information so you can decide upon what accommodation options might be present for the employee. And then, typically when you get that initial note, we often will advise if you have questions or concerns about that note, you're going back to the medical provider through the employee. You're not heading directly to an independent medical examination, for example. Often we're taking that initial information at face value, and then we're working with the employee, and if the union's present, with them as well, to talk about potential options. But we can move on to the next slide. Okay, so when we're dealing with the duty to inquire, you need to know that legally that arises when you as an employer know, or you ought to reasonably know, that there might be a connection between the employee's disability and poor performance on a job. So in such a case, you need to be inquiring into that connection before you're taking action against the employee for poor performance. So how it works in practice, I'll give you sort of a classic example. You have a maybe long tenured employee, unblemished employment record. They've been a really strong performer for you. All of a sudden, out of character for the employee, they're falling down in their job. Maybe not physically falling down, or maybe they are, but also just from a job performance perspective, they're not doing their job as well as they used to. Before you jump to discipline, You should be sitting down with the employee to say, hey, this is what we're observing. We're concerned. What's happening for you? Why is this occurring? Giving that employee the opportunity to tell you that something might be going on for them. And they might not. The employee said, I'm totally fine. What's your problem? But at least then you've asked the question to determine whether there might be something going on for the employee that may be a protected ground. And then we're potentially looking at potential accommodation. More often than not, if you've seen this out of character experience for your long tenured, really good worker, they're going to break down and say, you know, I've been diagnosed with a disability. I'm having trouble from a mental health perspective managing the news of the diagnosis, or I'm having difficulty managing the symptoms. You offer them your employee assistance if you have that programming in place. Perhaps we're giving them a short paid leave of absence so that they can get a questionnaire from us that they take to their physician. We're going to ask them a number of questions. So then we can start having a conversation about what they can and cannot do at work. Doesn't mean that you don't manage your workplace and ensure that the work is getting done, but it might mean that that employee needs some assistance. And then that would start your duty to accommodate from there. So there's many situations where I see employers fall down on the duty to accommodate piece because they don't know about it and they see poor performance and they jump to discipline without first saying, hey, wait a minute, is there any reason that we might suspect something's going on for this individual? This is strange and out of character for them. That's where you need to take a pause. Claudia, how does it work in Quebec?
So in Quebec, it's slightly different. We don't need to be as proactive as you would need in other common law provinces. We really need to be made aware of a situation or ought to be aware of a situation, but it doesn't go as far as asking the question when you see poor performance, all of a sudden that you want to know whether or not there's an underlying reason or medical reason for that. So there's case law on this, decisions of the Court of Appeal, also doctrine on it, where we must know as an employer, we must be informed at some level that there is a medical condition, for example, or a handicap. And then that is when the obligation to accommodate is triggered. So, for example, having a medical note is the obvious example. So, of course, once you get a medical note from someone, you have the information. So that's when your duty to accommodate is triggered. But it could also be as subtle as seeing someone with specificities in their physical appearance, red eyes or smell of alcohol, for example, that could trigger also a duty to accommodate. And you ought to have known that there may be an issue with alcohol consumption, dependence, or whatnot. But if there's no sign that an employer can observe and ought to know that there's an issue, then we don't necessarily need to dig further down as you would need in other provinces. So we must be informed, and that's part of the interactive process of the accommodation. The employee must, as a first step, inform or indicate to us in a manner or another that they have an issue, and then we could target what the protected ground is. And it's once that we're informed directly or indirectly that we need to gather all of the information to provide accommodation.
Yeah, and I would say for sure for the common law provinces, it's really that ought to have known that becomes an issue, right? Where you ought to have known in a situation where you have a long tenured, strong performer, unblemished record who all of a sudden isn't doing their job. That's really that trigger of, okay, instead of jumping to discipline, we ought to be sitting down with them and saying, what's happening for you? Are you okay? Before we jump. Otherwise, you may end up with a human rights complaint. And we'll move to the next slide to look at some examples where there have been human rights complaints against employers for missing the duty to inquire piece. So the first example that I've cited here is from the Alberta Human Rights Commission. This was brought by the estate of an employee who was named Donald Mitchell. So in this situation, the employee was a clerk at a liquor store. The employee attended at work very clearly and visibly intoxicated by alcohol. So feeds off of Claudia's example of where it's clear that somebody has come to work and they are intoxicated, which should have given rise to the question of, is this employee okay? Are they perhaps dealing with underlying alcoholism, which is a disability? Here, of course, he was sent home. He then tried to talk to his supervisor. The supervisor refused to have a conversation with him, didn't want to hear the explanation. He then was called in for a termination meeting. At the termination meeting, before he was terminated, he disclosed that he had mental health issues. He was going through a very difficult time financially, was dealing with bankruptcy proceedings. The employer said to him, essentially, you ought to have said something to us sooner, and proceeded forward with the termination. Very sadly, this employee died by suicide 2 months after the termination meeting. The estate then brought a human rights complaint in the estate's name to our Human Rights Commission, who found that there was discrimination here in the area of employment based on mental disability. The Human Rights Commission found that the employee, from looking at their medical records, had suffered from a mental disability, had been diagnosed with depression, anxiety, along with alcohol abuse. And the employer in this situation had not met its duty to inquire. So very sad circumstance and cautionary tale to employers to make sure that you are listening to your employees, even if they have engaged in misconduct or performance issues in the workplace. The second example that I provided on this slide is the Gregg and Carwell case. This was an employee who was terminated due to absenteeism, which we'll talk about in a little more detail today. This employee was addicted to alcohol. The employer, again, had fallen down in its duty to inquire and was awarded general damages of $25,000 and lost wages. So back pay was awarded to this employee as well. Claudia, did you want to take us through some Quebec examples?
So the two examples that I've included in that slides really deal with alcoholism. So the reason why I've included the first one is because I find it's a very long decision, and I'm not gonna go through all of the facts, because the piece about accommodation that I really wanted to focus on here is really the process to be followed, and when the duty to gather more information is triggered. But the first one outlines really well the process that you need to follow as an employer in Quebec. So I've included the reference if ever someone is interested in reading it and understanding a bit more. But what really comes out of the first decision is, yes, there is not necessarily a duty of it to inquire that is as strong as in other common law provinces, but there is, to some extent, especially when you have circumstances where you ought to have known. And in this case, it was a case dealing with alcoholism, sorry. And also what kind of obligation the employer had to, after knowing and being informed of the issue directly or indirectly. So I've included it in the slide. And same thing for the second one, the Teamsters Quebec. That's another good example of the process and how important the process is when you're informed of a situation and what kind of information you need to gather. And in that decision, they really talk about the lack of process and good process, and what kind of information you need to go get from your employees when you're made aware of the situation. So I'm not necessarily going to spend too much time on those two examples, but I wanted to include them in the slide anyway so that people can refer to it.
To the next slide. So following up on that, Claudia, you mentioned gathering medical information, which we've touched on. Employees certainly do have a right to privacy regarding their medical information. It's personal information. But employers also need to ensure that they have the information that they require to assess a request for accommodation, or to assess a situation where an employee may have said, I can't do this work because of an underlying disability. So certainly when that happens, we can ask for confirmation of the existence of a disability. We can ask for prognosis. We're not asking for diagnosis, but we can ask whether a disability is permanent or whether it's temporary. We can ask about whether there's a treatment plan and whether the employee is following that. We can ask if there's medication the employee is taking, not what they are taking, but we can ask if the employee is taking medication, will it affect their ability to safely perform their duties? Those are the types of things. And then, of course, as we've talked about, when we're dealing with accommodation, we can be asking about any restrictions or limitations. And when we're asking for that medical information, we're often providing information about the job description and the duties that the employee is required to do in their role. Really also important to include any safety information about the safety sensitive nature of the tasks or role that they're responsible for. And then there's a duty to cooperate. Employees aren't entitled to perfect accommodation, and they are very much entitled to be a participant in the process, but we need to force them to do that as well from time to time. So it's a multi-party process. They have to provide reasonably necessary medical information to support their request for accommodation, and to inform the employer about potential accommodation options. Claudia, does it work any differently in your jurisdiction?
No, it's somewhat similar, although sometimes you could be justified to ask the diagnosis, but in specific circumstances, the and a small note on that, the duty to accommodate is really an individualized process, so you really need to take a look at it in a given context. So it may be good under certain circumstances, but not necessarily under others. So in certain cases, you may be justified requiring the diagnosis. But what I wanted to highlight for Quebec is the specificity that we have. We have the Charter of Rights and Freedom in Quebec, which is a quasi-constitutional piece of legislation. And there is a balance between the type of questions that you need to ask and the reason why you're asking. So do you have a legitimate objective when you're asking those questions? Because if you don't, then you're asking too many questions when you're filling out that medical questionnaire, for example. You may be infringing privacy rights as well, which are protected under Quebec Charter of Human Rights and Freedom. So to give you a practical example, oftentimes, and Jill referred to that a bit before, but oftentimes when we have a situation where an employee informs an employer that they have to take a leave of absence and they have a disability of any kind, the first step is really to get a confirmation of certain information with the physician that's filled out the initial medical notes. And we may be tempted in asking too many questions. And if we just base ourselves on templates of medical questionnaires, it may be a slippery slope in Quebec because it may not meet the test of, was that question really a legitimate question with respect to your objective? Was it really necessary to ask that question to be able to come to your accommodation solution? So you need to be mindful of that and balance it out. So it's really specific to your given employees' duties and tasks and position, the questions that you need to ask. So whenever you are facing this kind of situation, be mindful of the situation that you're in. What does this employee need to do in terms of their job tasks and job duties? And are my template questions really necessary in this specific case? So I just wanted to outline that and highlight that for Quebec.
Yeah, it's very good advice for the common law provinces as well, particularly Alberta and British Columbia that also have private sector privacy legislation that governs the employment relationship and for federally regulated employees as well. Making sure that you're, not just having perhaps a standard form that you use for everybody, but making sure that you at least have a covering letter to your questionnaire that walks through what the particular questions and concerns that you have with respect to that particular employment situation. We'll move on to the next slide and we're going to talk about some of the emerging issues that we're seeing. So one is with respect to neurodiversity. And of course, we are all neurodiverse. Neurodiversity is just the natural variation in thinking that we each have as individuals. It's just how our mind works. But there are some diagnoses that are tied to the neurodiversity that we have as humans. We see diagnoses such as ADHD, autism, Tourette syndrome, dyslexia, amongst other things. And so this can, of course, show up in the workplace and often shows up when we're seeing either things that are viewed as misconduct or performance issues. And again, you're wanting to stop to do that duty to inquire to determine if there might be something underlying before we proceed forward to discipline. We also want to make sure with neurodiversity that you're not stereotyping. These diagnoses are going to show up very differently for each individual employee, each individual in person. So you don't want to make assumptions about the potential needs for accommodation or what accommodations may work in a particular circumstance. You're going to want to ensure that you're tailoring the accommodation to the particular employee. And again, you're going to want to ensure that you have that appropriate medical documentation before you proceed forward with that accommodation discussion. Some potential accommodations that we see in a neurodiverse diagnosis would be perhaps hybrid or remote work is needed. Maybe in-person oral instructions are required. Maybe the individual needs written instructions to be able to get back to you on. Maybe there's a one-on-one training requirement. Quiet workspace needs, noise canceling headphones. Those are all things that we see in practice that could be appropriate accommodation depending on the medical information that comes back. I've provided a couple of examples from Alberta. The first is an Alberta Health Services example where there was a diagnosis coming out of the neurodivergence of a registered nurse. This registered nurse had gone through an independent medical examination process, which came out with very specific accommodation requirements based on this individual's diagnoses. Things were working for a time, and then there was a change in management. And the new manager perhaps didn't understand or just did not follow those accommodation requirements. And we fell back into performance concerns with that RN. And then we resulted in a grievance, which went through the process and determined that there was a breach of duty to accommodate there. It's a lengthy decision, but it goes into detail about what is required in these situations if you wanted to have a read. The second Alberta decision that's there was a diagnosis of ADHD and PTSD. This individual employee used coping mechanisms in the workplace to help manage the symptoms of the diagnoses, including talking to herself during the workday and tapping. The employer told the employee to stop, ultimately terminated the employee due to the misconduct for not stopping these behaviors. And the employee brought a human rights complaint and was successful. Damages for discrimination were awarded in the amount of $50,000, and the individual received an award of back pay for lost wages as well. So some additional cautionary tales there. Claudia, you have a Quebec case as well.
Yeah, I included that Quebec case. Well, premièrement, cette décision-là porte essentiellement sur un cas où est-ce qu'il y avait de l'absence qui était persistante, so persistent absenteeism in the workplace. That's what this case deals with. And the employer was successful finally to get the grievance dismissed because they were able to show that there was no foreseeable resolution of the situation with the person who had a neurodiversity issue. And so what this decision shows, however, and it touches a bit on what you just said, Jill, is the importance of the individualized assessment in specifically in cases of neurodiversity and other types of trouble that we may see come up more and more. And I thought it was interesting to include it in there because it reminds employers of the individual assessment that you need to do, and what's good for one may not be necessarily good for another one. So you can have a read on that one, but it's essentially a situation where an employee had excessive absenteeism and the employer was able to show that there was no resolution possible. So very, very important and interesting case to consider.
Thanks, Claudia. We'll move on to the next slide, which is another emerging issue. So dementia and aging workforce, we're seeing more and more so that we have an aging workforce. People are working longer than they did before, which makes a whole lot of sense. We're living longer and it's really expensive to retire. And so we have questions from our clients from time to time about, look, this individual is not performing the way that they used to, or they're We're seeing memory issues. We're seeing concerns about the ability to be able to do their job. We just wanted to provide a reminder that, of course, individuals, whatever they're presenting with, need to be treated the same as any other employee would be. If you were to treat older employees differently, then that's age discrimination. So be conscientious that you're meeting your duty to inquire and you're documenting your process, you're gathering medical information where required. Really, these situations present in, from a legal perspective, just the same as any other situation you're dealing with in the workplace. And Claudia had provided some statistics from Quebec where the workforce is aging faster than the rest of Canada. So we are seeing a growing aging population, but even the statistics within Canada, the numbers are pretty stark. So back in 1998, only 4.2% of the workforce was over the age of 60. And then the stats from 2023 are that 12.3% of the workforce is over the age of 60 in Canada. So certainly is a growing segment of our work population and something to be sensitive to and mindful of as you're managing your workplace. And we'll move on to the next slide.
So now we're going to touch on process. We have a few minutes left. So I think process is key when you're looking at these situations. So many of the decisions that are reported in Quebec and the rest of Canada show that poor process sometimes is the key to succeed in failing the accommodation process and argument. As Jill mentioned at the beginning of the session, documenting is important. It's the most important thing that you should do. And when we talk about documenting, it's documenting every step. So it starts with when you were informed of the potential disability or the potential protected ground, what kind of information was communicated to you, because the type of communication that was communicated to you will have an impact in your process and the way that you're cooperating with the employee, for example, to find an adequate accommodation. So once you've documented that, you also want to document the options that you've looked at, and also internal discussions. It's really important to build that file internally so that if ever you end up in a hearing, if ever you end up before the courts, you have everything that's backed up on these processes that you followed. And it's so important because nowadays the delays before the courts in Quebec anyways is extremely high, and like human nature is such that we will have difficulties remembering what occurred 3 years ago. So it's really, really important to gather all of the information and document everything. You also want to make sure that you have a toolbox ready. So what we've included in that is the sample template. I was talking about the sample template medical questionnaire earlier. So it's important that you have in your toolbox documents such as the medical information requests, such as the confirmation of workplace accommodation once you've come up with a solution, such as the template communication with your employees, and that we're able to help you create and gather so that you don't have to reinvent the wheel every time, but having those templates will save you tons of time. You also want to make sure that you've included, as I said, the employee in the process, but if you're a unionized environment, you also want to include the union in your discussions in terms of finding a solution for accommodation. And you want to document your communications with the unions as well. If you think about a specific accommodation, that's great. You've achieved what we want to achieve as employers, but it's important that you foresee the future. How is that accommodation actually going to be implemented in real life? What is it going to look like? So one part of that process is to put together return to work agreements, ensuring that you have clear indications of what is expected of the employee, the new job duties, if ever you have new job duties, the limits to what the employee is to do in that new position. So have workplace return to work agreements in place already. And as I said, in Quebec and in other provinces as well, the accommodation process involves active participation of all parties and heavily rely on that, because if the employee is not giving you certain information, you will not be able to come up with the most appropriate accommodation process. We can move on to the next slide. When does accommodation go too far? And we tend to walk on eggshells when we have situations where we need to accommodate employees, but sometimes the accommodation requests just go too far, and we don't have to do that as employers. So we've given you a list here of what the employer is not necessarily required to do automatically. So you're not necessarily required to accept an accommodation that compromises safety, for example. You don't have to create a new job for your employee. You don't need to put your employees in positions that they can't perform. That is requesting too much of employers. And I wanted to give you an example of a decision that was rendered lately in Quebec quickly with respect to telework. And that is something that we see more and more. And I've given you a list, but requests to work remotely since the pandemic have gone through the roof. And oftentimes employers think that teleworking is something that they need to accept as an accommodation per se to an employee wanted to work from home after giving a medical note. But it's not automatic, and it's not in all circumstances where you absolutely need to accept telework. And the decision that was just rendered in Quebec, and I can send you the reference afterwards if you send me an email, is interesting because the employee had a medical note requesting to work remotely, and the employer was able to demonstrate that for their workplace and for that employee's position, it was essential that they come into work. Although they had to work sometimes with clients over the phone and through the use of their computer, the employer was able to show that they had a specific need for the employee to be in the office, and they did not have to accept the accommodation, which was to work remotely 100% of the time. And the employer was successful in demonstrating that. But why was the employer successful in demonstrating that? It's because they followed a very thorough process, and they were able to document the exact reasons why they needed to have the person in the workplace. So I wanted to give you that as an example of accommodation that you don't necessarily need to say yes to, especially in 2025 when it becomes a trend to request these types of accommodation. We can move on to the next slide now, Jill.
So we wanted to walk you through some tips and traps with respect to attendance management, because there is a big difference between employees who are not attending consistently at work because they're just not great employees, and employees who have something that's going on for them that might be a protected ground that's causing the absenteeism issues. So from a starting place, you want to, as managers of workplaces, really lean into the attendance management process. You want to make sure that all of your staff are aware of what the expectations are regarding attendance, including any procedures that you have in place for reporting absences. You want to make sure that you're going to be communicating those steps very clearly about what's going to happen for failure to meet expectations. Communicate any resources that are available to your employees if help is needed, including accessing sick leave or disability leaves, for instance. And then being mindful of what this slide talks about, which is the culpable versus non-culpable. So culpable meaning something that they're responsible for. Culpable absence is where an employee is absent due to factors that are beyond their control. For example, they've failed to report absences or are using improper, sorry, this is due to factors that are within their control. So they're not showing up to work, and they could show up to work. So they're not properly reporting their absences in accordance with your policies and procedures. They're improperly using a leave of absence that you have in place, or they're saying, I've had car trouble again, and it's something that keeps happening. That's something that might ground a disciplinary decision or eventually perhaps even termination for cause. A non-culpable absence, so something that they are not responsible for, is something that happens because it's beyond their control. So there's injury or illness, or there's a family emergency, other sort of unavoidable circumstance that might be grounded in a protected ground under human rights legislation. And we need to be careful to not address those situations with discipline, but rather address those situations through duty to inquire and meeting your duty to accommodate. But make sure you're managing this. After the first no show or no call, and even after the first one, make sure you're leaning into the process. And we'll move to the next slide. Sometimes you might need to part ways with a problematic situation, unfortunately, even where there are human rights considerations at play. So you might meet undue hardship. You may not be able to accommodate that individual because you've met the point of undue hardship, or the employment relationship may now be frustrated or may need to come to an end in a unionized context due to non-culpable absenteeism, because there's no prospect of that employee's return in the foreseeable future. Those are situations that could conclude the employment relationship due to nobody's fault. There are situations where we might end up even with a disciplinary termination when you're dealing with these sorts of accommodation processes. If you've got an employee who is not cooperating, who's being problematic through the process, they've been warned. Those are situations for sure where you might be looking at potential termination. If you are in or believe you are in a parting of ways situation as an employer, please call us. These situations are rife with potential liability. And with that, I think we'll move to the conclusion of the session. I believe that we have had some questions that have come through, but we will follow up with you each individually on those. Thanks for coming.
Thank you.